The very foundation of any criminal case rests on seemingly technical documents, the complaint and the information. Yet a misstep in these initial stages, from incorrectly identifying the court with jurisdiction to failing to precisely detail the alleged crime, can derail an entire prosecution, impacting both the accused's rights and the victim's quest for justice. Today, James, we are examining Rule 110 of criminal procedure, focusing on the crucial rules that govern the prosecution of offenses.
That's right, Isabella. Rule 110 sets the stage for criminal proceedings, outlining how cases are instituted, where they're heard, and what must be included in the charging documents. It's about ensuring due process and a fair trial, but also about the efficient administration of justice.
Let's start with the initiation of criminal actions. Many people assume courts can just stop a criminal case from proceeding. But in BPI versus Hontonosis Jr., we see that's not generally true, right?
Precisely. That case clarified that as a general rule, courts do not issue injunctions to prevent criminal prosecutions. There are narrow exceptions, of course, like protecting constitutional rights, or if there's a prejudicial question, lack of jurisdiction, or clear evidence of persecution rather than legitimate prosecution. But mere fear of facing a criminal charge isn't enough to secure an injunction.
So the default is to let the criminal process run its course. This brings us to another critical aspect. Who actually has the standing to pursue the criminal aspect of a case? In Heirs of Delgado versus Gonzalez, the private complainants tried to continue the criminal case when the Office of the Solicitor General didn't appeal. What happened there?
The Supreme Court ruled that the private complainants lacked standing. Once a criminal action is formally instituted, the state, represented by the Office of the Solicitor General or the public prosecutor, becomes the real party in interest for the criminal aspect. A private complainant's interest is generally limited to the civil liability. There are rare exceptions, but the OSG's failure to perfect its own appeal meant the appellate court's decision became final as to the state, and the private parties couldn't simply step in to revive the criminal prosecution.
That distinction is vital. Now, what about situations where an attorney might be a little too zealous in pursuing a case? In Lim versus Mexica, an attorney faced disciplinary action partly for allegedly forum shopping by filing a complaint directly with the court, while a prosecutor-level motion for reconsideration was still pending. Was that considered forum shopping?
Interestingly, the court said no to forum shopping in that instance, but did sanction the attorney for lack of candor. The key here is that for offenses not requiring preliminary investigation, the criminal action can be directly instituted in the proper first-level court. A prosecutor's investigation is not considered a final judicial adjudication that would create a parallel judicial action for forum shopping purposes. However, the lawyer's duty of candor to the tribunal still applies.
Speaking of time, criminal actions have deadlines. The concept of prescription, or the time limit for prosecuting a crime, seems fairly straightforward, but Zaldivia versus Reyes Jr. highlighted a crucial distinction. What did that case tell us about when prescription is interrupted?
Zaldivia established that for municipal ordinance violations under the then-applicable summary procedure, prescription was only interrupted by the institution of judicial proceedings. A non-judicial complaint filed with a prosecutor's office wasn't enough. In that specific case, the offense prescribed because the information was filed in court after the 2-month statutory period had already elapsed, even though a complaint was filed with the prosecutor earlier.
But that wasn't the final word on all types of cases, right? People versus Pangilinan seem to offer a different take for special laws.
Exactly. Pangilinan clarified that for offenses under special laws like Batas Pambansa Bli LG 22, the filing of a complaint for preliminary investigation with the proper prosecution office does interrupt prescription. The court distinguished it from Zaldivia by noting that Zaldivia's strict interpretation was tied to its municipal ordinance and summary procedure context and didn't mean that prosecutor proceedings never interrupt prescription for other types of offenses.
And Arambulo versus Lacqui Sr. further reinforced the idea that procedural missteps by public officers shouldn't penalize the offended party, correct?
Absolutely. In Arambulo, a libel complaint was timely filed with the prosecutor, but the information was mistakenly filed in a court that lacked jurisdiction. The court held that prescription was nevertheless told by the timely complaint and ensuing proceedings. It emphasized that a complainant shouldn't lose their action due to an official error, as long as the proceedings were commenced seasonably and in good faith.
Let's move to the prosecution of criminal actions. World Wide Web Corporation versus People brings up an interesting point about what constitutes a criminal action in the first place.
This case makes a crucial distinction. It ruled that a search warrant proceeding is a special criminal process initiated by an application for a warrant, not a criminal action commenced by a complaint or information. Therefore, Rule 110, Section 5, which deals with the public prosecutor's control over criminal actions, doesn't apply in the same way to search warrant applications and their review.
So, private parties have more leeway in search warrant matters. Now, when dealing with public officials, the ombudsman comes into play. Busuego versus Office of the Ombudsman addressed questions about overlapping investigative authorities.
Yes, it affirmed that the ombudsman and the regular prosecution service can have concurrent investigative authority. However, the ombudsman possesses primary jurisdiction over offenses involving public officers, regardless of whether the crime was committed in relation to their office, and can exercise that authority, sometimes taking over a case from the DOJ. The existence of other prosecutorial authority doesn't negate the ombudsman's power to proceed.
This leads us back to the role of the private complainant versus the state. In La Jimenez versus Sorangan, the private complainant tried to seek appellate relief without the OSG. What was the outcome?
The private complainant lacked the legal personality to pursue the criminal aspect in the appellate court. The ruling reiterated that criminal actions are prosecuted under the direction and control of the public prosecutor at trial and by the OSG on appeal. The private complainant's independent interest is typically limited to the civil aspect, unless there's a recognized denial of due process exception, which wasn't found there.
But prosecutorial discretion isn't absolute, is it? Chua versus Padillo showed that courts can intervene if there's grave abuse of discretion.
Absolutely. That case affirmed that while prosecutors have broad discretion, it's not unchecked. When prosecutorial authorities arbitrarily disregard material evidence directly bearing on probable cause, courts can correct that grave abuse of discretion through certiorari. It's an important check on the executive's power to prosecute.
And the absence of a prosecutor can have serious consequences, as seen in Pinote versus Aiko.
Indeed. In that case, the judge allowed defense witnesses to testify while the public prosecutor was absent and no properly authorized private prosecutor was present. The court ruled this violated Rule 110, Section 5, and the state's right to due process. The public prosecutor represents the people, and proceeding without proper representation or authorization undermines the state's ability to participate meaningfully.
Moving to the complaint or information itself, Rule 110 requires precision. Ampatuan Jr. versus De Lima deals with the prosecutor's discretion in charging, even when a participant admits guilt.
That's a complex scenario. The case confirmed that prosecutors have broad discretion in determining whom to charge, especially when mechanisms for state witnesses are involved. If a person is admitted to the Witness Protection Program under RA 6981, they can receive immunity. The court won't compel a prosecutor's discretionary choice via mandamus unless there's a clear ministerial duty, which wasn't the case here.
So the prosecutor has significant power in these decisions, and even fundamental requirements like a sworn statement are crucial, as in Oporto Jr. versus Monserrate.
Correct. That case highlighted that a criminal complaint must be a sworn written statement. The judge's handling, where an unsworn complaint was accepted and then mishandled regarding preliminary investigation and jurisdiction, was deemed gross ignorance of basic criminal procedure. It underscores that judges also have a duty to ensure these foundational requirements are met.
Salazar versus People also touched on the offended party in preliminary investigation. Could anyone initiate it?
Generally, yes, for public offenses. The complaint defined in Rule 110 refers to a sworn pleading filed in court to commence a criminal action where the law requires it. But a complaint affidavit filed with a prosecutor to initiate a preliminary investigation can, as a rule, be filed by any competent person unless the offense cannot be prosecuted de officio.
And what about seemingly minor administrative requirements for legal documents? People versus Arrojado showed these can have significant consequences.
Indeed, the murder information in Arojado was dismissed without prejudice because the prosecutor failed to include her mandatory continuing legal education compliance number and date as required by the then applicable Bar Matter number 1922. The court found the information to be a pleading under that rule, and the RTC did not gravely abuse its discretion in dismissing it when an express Supreme Court administrative requirement was not followed. It highlights that even administrative rules impact the validity of charging documents.
Moving on to the sufficiency of the information itself, People v. Sandigan-Bayan, 4th Division, discussed the level of detail required for a complaint charging an offense like anti-graft and corrupt practices.
That case emphasized that for a motion to quash, the information must allege the ultimate facts constituting every element of the crime, but it doesn't always need to plead evidentiary details or a precise peso value. The Sandigan-Bayan initially quashed the information for not specifying the exact amount of unwarranted benefit or injury, but the Supreme Court reversed, stating that such quantification was a matter of proof at trial, not an indispensable pleading fact.
So, ultimate facts, not evidentiary minutia. And what about the exact date of an offense? Zapata v. People addresses this.
Zapata confirmed that the precise date of an offense need not be alleged unless time is a material ingredient of the crime. It's sufficient to allege an approximate date. A minor variance between the alleged date and the proven date isn't fatal if it doesn't mislead the accused or prejudice their defense. In qualified theft, the exact day isn't an element, so an approximate time frame is acceptable.
When it comes to identifying the accused and specific aggravating circumstances, Bali Belita v. People provides a critical lesson.
This case illustrates that every element and qualifying circumstance that changes the nature or penalty of an offense must be alleged with certainty in the factual recital of the information. A mere description attached to the identity or name of the accused in the caption isn't a substitute for explicitly stating that qualifying fact as part of the cause of accusation. Due process requires the accused to be clearly informed that a particular relationship, for example, is being relied upon to qualify the offense, leading to a higher penalty.
This links to the designation of the offense, which can be tricky. Valdez v. People highlighted that legal labels aren't enough. Factual allegations are paramount.
Precisely. Valdez demonstrated that the real nature of the charge is determined by the factual allegations in the information, not merely by the caption or a bare legal conclusion like treachery. Qualifying and aggravating circumstances must be alleged through facts sufficient to inform the accused how they attended the crime. Just saying qualified with treachery without factual details isn't enough to sustain a murder conviction over a homicide.
But an accused can waive certain defects, right? Azalan v. People speaks to this.
Yes, Azalan reinforced the idea that while qualifying circumstances must be properly pleaded, objections to defects that are waivable must be raised before the plea. If an accused doesn't timely move to quash an information and allows the prosecution to present evidence on the qualifying circumstance, they may be deemed to have waived the defect.
So the onus is on the accused to object early. Bayabos v. People further emphasize that statutory labels are insufficient on their own.
Indeed. In that hazing case, the information used the term hazing, but failed to allege the crucial fact that the acts were a prerequisite for admission into an organization, a necessary ingredient of the crime. The court ruled the information insufficient because a technical or statutory label is a conclusion of law and can't replace the ultimate facts that make the conduct criminal.
The cause of accusation itself is central. Dungo v. People examined whether there was a fatal variance between the offense charged and the offense for which the accused were convicted in a hazing case.
Dungo clarified that the cause of accusation is read from the information as a whole. Even if the information explicitly charged actual assault, allegations describing a planned initiation, conspiracy, presence, and violent acts could sufficiently embrace the statutory modes of participation proven at trial, like inducing the victim to be present. The key is whether the accused received adequate notice of the criminal transaction and theory against them.
Venue is also jurisdictional in criminal cases, as Navaja v. De Castro clearly established.
Navaja underscored that criminal venue is an essential element of jurisdiction. The action must be instituted where the offense or any essential ingredient occurred. The information needs to allege the place sufficiently. If trial evidence ultimately shows the crime was committed elsewhere, the case must be dismissed for want of jurisdiction. In that falsification case, witness information and charging allegations showed the alteration was made in Jagna, making it the proper venue.
Who is the offended party under Rule 110? Li Pui Liang versus Chua Pui Chin Li clarifies that even for public offenses, a private individual can be an offended party for civil liability.
That's an important point. The court explained that Rule 110 defines the offended party as the person against whom or against whose property the offense was committed. Even in a public offense like perjury, a private individual or juridical entity directly injured by the punishable act may be considered an offended party for purposes of civil liability and can intervene through counsel, subject to the public prosecutor's control.
Senador versus People further adds nuance to the offended party issue, especially in property crimes.
It did. Senador established that for offenses against property, an error in the name of the offended party is not necessarily fatal if the property or transaction is described with sufficient particularity to identify the offense. Rule 110, Section 12 allows for correction. The materiality of the error depends on whether the accused was truly misled about the specific criminal act charged, not just the identity of the complainant.
Now let's tackle duplicity of offense. Jugueda versus People dealt with informations charging double murder and multiple attempted murder.
Jugueda is key here. Rule 110, Section 13 generally requires only one offense per complaint or information. Duplicity is a ground to quash the information before plea. If the accused fails to object timely, the defect is waived, and the court can then convict for as many offenses as are charged and proven. So in that case, because Jugueda didn't object, he was liable for separate counts of murder and attempted murder.
But duplicity isn't the same as multiple charges from a single incident, is it? Loney versus People highlighted this distinction.
You're right. Loney clarified that duplicity means one complaint or information charges more than one offense. It doesn't arise merely because several separate informations charge distinct offenses stemming from the same act. One incident can indeed violate different laws if each offense requires an element not present in the others, subject to double jeopardy limits. So, multiple charges for environmental violations and reckless imprudence from one mine pollution incident were allowed.
And People versus Court of Appeals further solidified the waiver rule for duplicitous informations.
That case reiterated that if an accused doesn't move to quash a duplicitous information before plea, the defect is waived. Once waived, the court can convict for as many offenses as are alleged and established by the evidence. The purpose of the one-offense rule is to provide notice and allow for an orderly defense, and failing to raise the objection timely signals that the accused was not prejudiced.
Amendments to the complaint or information are also a frequent point of contention. Balandong versus Court of Appeals focused on when the substitution mechanism under Rule 110, Section 14 applies.
Balandong underscored that Section 14, which allows substitution if a mistake has been made in charging the proper offense, is not a tool to relitigate a charging determination that's already been extensively reviewed and finally resolved through the prosecution and appellate process. If there's no unresolved mistake in the offense charged, the mechanism isn't available to simply seek a different probable cause determination.
So it's not a backdoor for endless appeals on the same issue. Mendez versus People distinguished between substantial and formal amendments after a plea.
Mendez provided clarity here. After a plea, only formal amendments are allowed with leave of court, and only if they don't prejudice the accused. A formal amendment doesn't change the offense, alter the prosecution's theory, deprive the accused of a defense, or change facts determinative of jurisdiction. It merely adds precision to existing allegations, like clarifying a taxable year or business branches in a tax non-filing case.
And Ocampo versus Abando dealt with the political offense doctrine and how it interacts with the substitution rule.
Ocampo highlighted that if trial evidence eventually shows that a mistake was made in charging the proper offense, for instance, that an act initially charged as murder should, due to political motivation, be rebellion, Rule 110, Section 14, allows for substitution. The original information can be dismissed upon filing a new one for the proper offense, provided double jeopardy isn't violated. This emphasizes that even if a case proceeds as a common crime, the door is open for reevaluation based on trial evidence.
Let's revisit venue with Union Bank versus People, specifically for perjury cases.
Union Bank clarified that criminal venue is jurisdictional. For perjury, the action may be instituted where the offense or any essential ingredient occurred. Since perjury is consummated through a willful false statement under oath before a competent officer, the place where that statement is executed or subscribed is material to venue, even if the false document is later used elsewhere.
And Congress has the power to create exceptions to general venue rules, as seen in Stowe, Tomas versus Salek.
Indeed, Stowe. Tomas affirmed that Rule 110, Section 15's phrase, subject to existing laws, means Congress can validly create statutory exceptions. R.A. number 8042, the Migrant Workers Act, allows illegal recruitment cases to be filed either where the offense occurred or where the offended party resided. This special venue advances the protective policy of the law and is not considered arbitrary.
While we're on venue, Yalong versus People is an important procedural reminder, even if it's not a new Rule 110 venue doctrine per se.
Yalong is a crucial cautionary tale about appellate procedure. It stresses that when a regional trial court decides an original action, like a Rule 65 certiorari petition, the correct way to appeal to the Court of Appeals is by filing a notice of appeal under Rule 41, not a petition for review. Using the wrong mode of appeal or interchanging them after the reglementary period can lead to dismissal and finality of the lower court's decision.
Finally, the intervention of the offended party. Villalon versus Chan explicitly recognizes their rights.
Villalon confirms that Rule 110, Section 16, allows an offended party to intervene by counsel when the civil action arising from the offense is deemed instituted with the criminal action. This right is only lost if the civil action is waived, reserved, or previously instituted. Even in a public offense like bigamy, the civil injury suffered by the spouse allows for private intervention, subject to the public prosecutor's control.
Let's touch on some other related issues. People versus Feliciano addressed allegations of aggravating circumstances, specifically disguise in a fraternity rumble case.
Feliciano clarified that an information is sufficient if it alleges the statutory offense, its elements, and enough factual detail for the accused to prepare a defense. Aggravating circumstances must be alleged to be appreciated. The court held that even if masks fell off during an attack, the initial allegation of disguise for concealment was valid, as it was part of the prosecution's theory.
People versus Begino, a qualified rape case, highlighted the need for careful pleading of qualifying circumstances.
Begino illustrates that qualifying circumstances that increase the penalty must be both alleged in the information and proven beyond reasonable doubt. In that case, the accused was charged as the victim's stepfather, but proven to be her common-law spouse. This meant the higher qualified rape penalty couldn't be imposed because the specific relationship as a qualifying circumstance wasn't precisely alleged in the information.
And when multiple acts are involved in a crime, how does that affect the number of charges? People versus Lucina addressed this in the context of multiple rapes.
Lucina confirmed that each completed carnal act, if accomplished through force or intimidation and reflecting successive and distinct criminal impulses, may constitute a separate rape, leading to multiple rape convictions. The key was that the victim's testimony showed separate penetrations with pauses, indicating distinct acts rather than one continuous offense. The information, by detailing these acts, provided adequate notice.
Finally, Tuando versus People reiterates the fundamental principle about conviction only for clearly charged offenses.
Tuando reaffirmed that an accused can only be convicted of an offense clearly charged or necessarily included in the charge. Rule 110 requires both the designation of the offense and the factual allegations constituting it. In Tuando's case, the information adequately alleged the sexual act, the victim's age, her relation to Tuando through his common-law union with her mother, and his abuse of authority. Since the proof corresponded to these allegations, his conviction for qualified rape was affirmed without violating his right to be informed.
These cases from Rule 110 truly highlight that the way a criminal case begins, from the filing of the complaint to the detailed drafting of the information, is far from a mere formality. It's a precise legal dance where every step impacts jurisdiction, due process, and ultimately the outcome of justice. Understanding these intricate rules is fundamental for anyone navigating the criminal justice system.
Absolutely, Isabella. The seemingly technical requirements of Rule 110 are the bedrock upon which fair trials are built, protecting the rights of the accused while enabling the state to pursue justice effectively. Any deviation or misinterpretation at these early stages can have profound and lasting consequences.
If you found this discussion insightful, please share this episode with anyone interested in the foundational rules of criminal procedure.